by law if she is provided psychiatric medications to treat her psychotic illness. That being stipulated to, I placed that in a journal entry on September 13th last week. And then on Monday of last week, the 16th, excuse me, the 13th was a Friday. On the 16th, I placed an order based on what the doctor provided us from North Coast. He opined again that involuntary administration of drugs is medically appropriate for her condition, Miss Ellis's condition. So involuntary administration, meaning if Miss Ellis cooperated, that the medication is substantially likely to render her competent to stand trial and come back here to the court and face those charges that are currently pending. Miss Ellis is at North Coast, which is a lockdown facility. So while she's been moved from our jail in a lockdown facility, she currently is in a lockdown facility where she is receiving her treatment. Doctor went on to say that these medications involuntarily administered are going to most likely have no side effects, will not interfere significantly with her ability then to assist counsel in conducting a trial in this matter. The doctor went on to say that if Miss Ellis is not voluntarily taking her medications, that the doctor would ask that I allow North Coast Behavioral Health Care to administer those medications by forced meds. I did find that appropriate, and I did sign that into a journal entry that if Miss Ellis does not voluntarily take her medication, I have ordered forced medication to be provided by the staff of North Coast Behavioral Health Care. And those are the entries that are pending now before this court as Miss Ellis will continue with her treatment at North Coast. Again, Ms. Ferrali, I believe, having reviewed those, I know that you had an opportunity to review those. Is there anything regarding the stipulation or what I've noted here on the record that I have not completely outlined or that you would want to add to here this morning?
Not at this time, Your Honor.
All right, thank you. And Mr. Mack and Mr. Johnson, do you believe I've indicated correctly those findings in the report, the stipulations that you have, and the entries that I've placed with respect to Miss Ellis?
Yes, sir.
All right, thank you. All right, and then finally, I'll just move to just one other thing that I noted as I reviewed the file. I think back on August 26th, there was a request for CCDFS records, the Children and Family Service records. I know that I provided those to you both, and I just want to know that you both have had an opportunity, both counsel for the state and Miss Ellis, to review those records, and if there were any concerns that you had, I'd ask you to let me know that. But Ms. Ferrali, I know the state was provided them. Have you had a chance to review those records?
Yes, Your Honor, we have them. We reviewed them.
All right, very good. And on behalf of Ms. Ellis?
Likewise, sir.
Okay, very good. All right, again, noting those findings by the doctors and the courts moving forward with allowing her to reach her capacity of competency at North Coast, I'll allow that treatment to continue. And if Miss Ellis is not voluntarily taking her medication, I have ordered the forced meds to be given to her by the staff at North Coast. And that's what I wanted to update here today. So until we have further updates from North Coast, the matter will remain pending until her treatment at North Coast. Is there anything further from the state? And again, I thank you for being here early for the court. All right, thank everyone for being timely. North Coast, thank you. Ms. Ellis, thanks for being present as well. And then we'll adjourn here this morning.
Dan DeRose with 19 News as we watch Miss Bianca Ellis being taken back. She is in custody. That was a live video stream from the North Coast Medical Facility. You heard that this was really a status hearing to be able to get things on the record. Miss Bianca Ellis has been found incompetent to stand trial of the stabbing of 3-year-old Julian Wood in the Giant Eagle parking lot in North Olmsted. This attack happened back on June 3rd. It really grabbed a lot of headlines. You heard the judge say that the initial doctor's findings was that she had schizophrenia. They also explained that she has had some psychotic episodes. But after being evaluated by the doctors at North Coast, they said initially if she voluntarily, and this is kind of the steps that have to be taken, if she voluntarily took meds, she could be returned to a status of competent so that she could actually go to trial, understand what's happening and what's at stake. That's the first step. When she doesn't take those meds voluntarily, they have to come back to court. It has to go back on the record where the doctor has now said that if she is forced the administration of those meds, she could be returned to competency. The judge had to agree, had to sign off on it, and that's what we get today. So while she hasn't been taking her meds, life is about to change for Bianca Ellis. She will now be forced. We're not exactly sure how you force someone to take meds, whether that's just simply watching them, whether that is intravenously, but she will now be forced to take meds while still being locked up to try and get her back to that competent level to stand trial. She's not getting off. A lot of people think when you hear the phrase incompetent to stand trial that it just means you're set free or you're taken to a hospital and that's it. That's not the way this works in the state of Ohio. She will remain locked up at the behavioral center. She will now be forced to take her meds, as the doctor said, to return her to competency to stand trial for that Giant Eagle parking lot stabbing. We're going to wrap this up. If we have any other breaking news, it'll be here on our digital platforms. Otherwise, watch for our 11 o'clock news on CW43 and our noon news on Channel 19. Until then, I'm Dan DeRose with 19. Have a good day.
19 News is everywhere. Download our CTV apps and follow us on social media @Cleveland 19 News.